So let's continue. Based on the questions in the break and over email, I just want to say a few words on this paper, and that I emphasize the disruptive element of it. So it is deliberately a role play, and it is deliberately a role play where you are put in a sort of autonomous position to think through what the best professional product would be in a simulated setting. And I encourage you to in the remaining 24 hours to see whether you can add to that autonomy character. So to avoid, for instance, that you give answers to the questions of the course description, pertaining to question 1, pertaining to question 3, and so that in the role play you make it more autonomous, to make it more your own words, that you crawl into the skin of that fictitious client and take that person by the hand. So it's not a school task like equation 1, equation 2, like with mathematics. So that's 1. 2, that I pitched that sort of lineup of activities: explanation, description, explanation, prediction, and advice, in the sense of sketching options how to cope and change things. That is just a general logical feature of intellectual thinking. And we had an interesting discussion on that third step. So obviously you don't spend the whole chapter on the prediction part. Prediction is just that you say, my explanational thingies, with theories and stuff like that, is also valid tomorrow morning. That's all. So that is not a independent thing. It's just a step that is made explicit in the intellectual sort of atmosphere we try to operate. Why? Because you should be prepared step by step to take the lead. And you ask a question, not your boss, not the teacher, lecturer. We are nothing, because it's your world in a couple of years. And so try to ask yourself, is the word choice equivalent with this sort of atmosphere of autonomy? Or is the word choice sort of student-like? Like, according to the course description, we needed to answer question 1. That's not matching up to your salary slip. I predict you deserve. And so that's the whole thing. Because after all, we produce words, so that's our business. So that is why I reflect on the words and ask you to reflect on your own words. That's the whole thing. Okay. Anything else on the paper? Yes, and then the presentation is 10 minutes. So with 2 persons, 5 each. And avoid that one person is doing the introduction. Today we will discuss about, and that the other person is having the beef, the flesh on the bones. So make sure that each person has flesh and bones. Because that is what makes you getting your salary. Yeah? Alright. Bankruptcy. Next theme. With the symbolic death, rest in peace type of icon as the opposite of the baby feet, symbolically, of the bird. With, again, the terminology, it's starting with the situation where the corporation, the enterprise, so the legal person, so this is not on group level, not on legal person level, is not satisfying the creditors. And satisfying the creditors, the course of Michael Milo, September this year, is that you are not living up to your obligations, which is difficult language of not paying your bills. And then obviously, these claims should be due. So if you have a loan of $500 billion with the Chase Manhattan Bank, and that is a 30 years loan, or a 10 years loan, then in year 2 it's not due. So yes, you have a debt, but it's not due. So don't get lost in stating, well, I see on the financial statements a lot of debt. That means this company is in default. No. Debt and default are two different things. Debt is, in the future there will be a day that I have to pay $500 billion to the Chase Manhattan Bank. And we have a plan, because by that day we have the money. Not the day before, on that day we have the money. Only when on that day you're not paying, in 10 years' time, then you're in default. So that's step 1. So, a lot of despair in the economic world is that people dislike each other, that they are unsatisfied with the contract terms, and then they scream like, you're in default, you're in default. That's emotion. That is what lawyers should have, and with your 30 credits lawyers' brains, your first reaction with screaming is, let's check the books. So screaming you're in default doesn't mean anything. Check the contract. Is the debt due on that debt? That's that one. And only if that is a situation that is sort of structural, as in 2 weeks, 3 weeks, 2 months, 6 months, depending on the jurisdiction, then the legal system moves to the bankruptcy language phase, with procedures, with requirements. For instance, 2 creditors should be unhappy, a court should be involved, certain publications should be made in national newspapers, sort of legal nitty-gritty around the technicality. And then, in view of this course, the critical step is the discontinuation of the agency. As in, that the ordinary course of management is discontinued and there's a change of actors. So shareholders are put at bay, boards are dismissed, and a trustee is taking over with a different role play, where all of a sudden those creditors are the critical players. Let's make a drawing. legal person, and then the shareholders and the meeting and the board, that's all cut off. Then we have the creditors, so the banks, the suppliers, the tax authorities, the employees, the customers. So it's a huge group. They all of a sudden have a claim on the assets, and then the court and a trustee as a new board is taking over, and the principals are the creditors, and the firm or the estate is the agent. And the appointment of the trustee is then done by the court, although when we discuss the creditors, you could frame that as a appointment right strategy of creditors. So here you see a clash. A lawyer would say the court appoints the trustee, but conceptually, by triggering the bankruptcy procedure, the creditors make it happen that a trustee is appointed, which you could frame as appointment right strategy. But let's discuss that in a minute. Well, the task of the trustee is to manage the assets and to satisfy the creditors. And then at the end of the classical procedure, it's technically called liquidation. So then the legal person is deregistered. So this is the classical approach to the quick and dirty business law steps that you have to reckon with in the context of bankruptcy. However, managing assets could also mean something else. Because remember, a firm is nothing else than a coordinated bundle of contracts around assets, intellectual property rights, customers, clients, markets, products. And the dream is that that bundle of contracts continues to have a certain value for other owners. So the ultimate dream of managing assets is not to sell the individual, t-shirts of Hudson Bay to consumers. No, to sell the whole up and running shop called Hudson Bay to another owner, who then puts HEMA or Bijenkorf on the outside. And to facilitate such a efficient handling of value from an economic perspective, legal systems facilitate this bankruptcy procedure in such a way that such a restart, this sort of selling of the whole business as a whole to someone else, is facilitated. And these facilities are, for instance, in the United States of America, put in a piece of their legislation, and more in particular in Chapter 11 of that legislation of the federal United States. Remember, Delaware corporate law was Chapter 8, and so all their legislation is put in a chapter. And pertaining to all the flavors within the realm of bankruptcy, all these rules are in a chapter called Chapter 11. And that is why in the newspapers, in American bankruptcies, they don't call it bankruptcy, but the firm is in Chapter 11, which includes that they explore, who is they, creditors and the trustee, whether there's a chance to sell off the whole bundle of the firm to another owner, which is economically preservation of value. Ideally with some labor contracts so that people keep their job. And if that does not work, then you also in chapter 11 move to the paragraphs where it says, okay, then the bits and pieces have to be auctioned. You know, company cars, company laptops on eBay, some raw material or whatever is not secured by banks and creditors. That's then sold off. And then the proceeds. So proceeds are the profit of that sale by the trustee. So whatever buyers pay on eBay on, you know, those laptops of Imtech, then the proceeds is the money that is paid for the laptops and the cars and the, you know, chairs and stuff like that. And distribution is nothing more than that you make a list of all those creditors in a certain priority. So in law school, a whole week is ruined on the ranking of all those creditors. And you already know, well, the top rank is the tax authorities, the banks take the real estate anyhow, and then the money is not there anymore. But legally speaking, there's a sort of ranking, you know, with employees and unions and social security and all kinds of types of creditors. Let's move to some law clauses, rule clauses, legislative clauses. In the Netherlands, or let's continue the story of the United States of America. Chapter 11. So this 11 is just 11, and in chapter 1 there's this rules on the presidency, and then in chapter 13 there's administrative law, and in chapter 27 there's military law. So they consolidated all their legislation in one piece with chapters. Very efficient. We should do that too. And then this typical legislative language. It says in Article 541, the commencement of a case under section 301, etc. of this title creates an estate. So chapter 11 is sort of, like many legislation, a little bit sort of mystique. So it doesn't say, like in the Netherlands, a corporation shall be declared bankrupt. So the United States has this sort of Anglo-American approach that they say, well, there's a procedure, and then the outcome is an estate. Don't ask me whether that's a declaration of bankruptcy. The only thing I know for sure is there is an estate. And so those are styles of legislation. Doesn't mean anything substantively. So one way or the other, a chapter 11, a bankruptcy procedure produces this estate. That's the bottom line. And then we have a lot of history in terms of examples. Already starting in the 15th century, that the Medici Bank, you know, from art class, the Medici, the fosterers of art in the Renaissance, and they had banks, and they went bankrupt. And the East Indies trading companies, they went bankrupt. And the Krupp Company in 1873, and the Daimler Bank in 1931, etc., etc. And recently, we talk about the Enrons, Arthur Andersen. Grandpa is telling stories. In the old days, there was not a big four, but a big five. Ernst & Young, PricewaterhouseCoopers, Deloitte, KPMG, and Arthur Andersen. And that one went bankrupt around the financial crisis, Not the last one, but the one around 2001. So people like you, with your degrees, who worked for a bankrupt company and lost their job. So, and then this is the Cadillac 2009, which is part of General Motors. And those are examples, for instance Cadillac, or General Motors I must say, where they succeeded in selling or reinventing the company with new shareholders, new investors, and they saved jobs, etc., etc. But remember that with those success stories, there is a sort of visible hand, not the invisible hand, but the visible hand of the state who facilitates this transaction with subsidy. In the Netherlands, with the nationalization of the banks. So certain bankruptcies are too inconvenient for societies to actually happen, and then taxpayers' money is used to facilitate this transformation from a bankrupt estate to a continuation of the business. Because economics is one thing, but to actually make it happen, it's not so easy. And so there you need external funding to satisfy creditors who thought, oh, let's sell the bits and pieces, you know, the trademark of Cadillac to Fiat and to the Chinese and to, you know, there are buyers. You're sort of European, so you do not have a sort of emotion with Cadillac. But it's like Rolls-Royce, you know, for Americans. Sort of intense trademark, ladies. That sort of world out there, you know, emotion. All right. So banks, you know, car companies, insurance companies, whatever, up to and including bakeries and snack bars and everything goes bankrupt. And then funny thing, just as a footnote, in certain jurisdictions, like in the United States of America, also public corporations can go bankrupt. And if you then realize that cities are incorporated entities in the United States of America, and you add these theories up, then cities can go bankrupt. Which is a bizarre thing from a European perspective. But it's basically that they are in default, they stop paying their bills. That can happen if you do not manage your balance sheet in a proper way. And then someone, the visible hand of another state organ, should step in, and then a new incorporated entity is created. Basically that happens in Europe as well. The taxpayers' money is going to, you know, the city of The Hague or Vienna or whatever to help them out. But that is technically a sort of bankruptcy situation where there's a continuation, the bundle of contracts called municipality. And so that's a use of these concepts in other areas like public law. Well, using the other keywords of the grand table of this course, connected to bankruptcy, you can tick off all the other boxes. So what about the delegated management? That is discontinued. What is about the shareholder ownership? There's nothing to own, so that stops. What about limited liability? Well, that is scrutinized around the duty of care of management and of the shareholder, if any. But if that is not translated to a claim, then it's sort of not relevant anymore. What about transferability of shares? That also stops, because if there is no legal entity anymore, and then there's no capital divided in shares, so there's nothing to trade. And the first core characteristic, the legal person, when it is deregistered, there's no legal person. And so you could use such a theme to show off that you understand what the other core characteristics is. So in the exam, very concrete student tip. If there's no question in the exam on tell me about the core characteristic, but at the end there's one question about bankruptcy, then as preliminary remarks, show off that you realize what the 5 core characteristics are and how they work out in bankruptcy. Maybe I should emphasize that preliminary remarks is the golden egg of your future career. So yes, there are concrete questions. How do I establish a corporation in Georgia? And the answer is go to the booth and get it done. That's 3 minutes. Then you get €10 selling. But you can have, with selling your preliminary observations, you can put establishing a legal person in Georgia in the wider perspective of entrepreneurship, shareholder ownership, long-term, short-term targets, ambitions, economic considerations, etc., etc. Secondly, the bankruptcy theme has 2 more aims. One, it sharpens your understanding of what liability is, and then the liability in terms of the limited liability of the managers and the shareholders. With the theme of last week, in the Dutch setting, Article 138 of Book 2, where it says that in case of a bankruptcy, and in case the estate of the bankruptcy is not large enough to satisfy all the creditor, in that situation, a manager is personal liable if and when he did certain behavior prior to the bankruptcy, which is classified as not in line with the duty of care and causing the bankruptcy. And what do I mean with sharpening? The whole idea that there is such a thing as bankruptcy is a 24/7 wake-up call of each and every single business decision from a lawyer's point of view. So what is the legal department basically assessing when you come up with a deal proposal, you know, selling Coca-Cola in the Philippines? They translate all these elements of that deal to potential risks for and in bankruptcy. So as a measure. So that's one. 2, it also sharpens, and I just repeat that theory, and repetition is an indication how likely it will be end up in the exam. It helps you to understand the core strategy called affiliation. Affiliation as in new shareholders joining the club, new creditors joining the club, new board members joining the club, new supervisory board members joining the club, new employees joining the club. Affiliation is ex ante strategy, meaning in the law utilities that facilitate the scrutiny around the affiliation with disclosure and due diligence and all kinds of other mechanisms to actually look into the corporation prior to contracting with it or to becoming part. And what is that scrutinizing all about? That is putting this sort of X-ray on the firm. Is this likely to go bankrupt, yes or no? Ultimately. Sure, it is scrutinizing, will it give me profit? Will it, you know, give it return on investment? All kinds of business analysis steps, sure. But from a legal perspective, when you talk about affiliation strategy, then it's about the bottom line. Is this a sound, solid, legally speaking, solid enterprise? Yes or no? That's the whole story. And if I don't know, insurance policy. Just in case. Why? Because if you are part of the club, you are sort of paid by limited liability, but there are these limits to it. Last but not least, a few words on the creditors. The terminology, I mentioned it already, so many actors, contractors could be called the creditor. And then the critical issue is obviously who is the agent, who is the principal, and then the primary relationship. The primary relationship is the primary obligation, as in providing advisory services by KPMG or providing raw material for a steel company. And so the primary relationship is just the day-to-day relationship, and then the underlying one is this relationship. What is the relationship of the creditors with the asset? And this slide, I finish with this slide, is just a study guide to get yourself prepared in 2020 for the exam, where it comes to the creditors. A division in two flavors, called the shareholder constituencies and the non-shareholder constituencies. And I like the word constituency. It's sort of British word. You know, groups of actors. And in the non-shareholder constituencies, you have the workers, we discussed on the 8th of January, and the society at large, which we will discuss in week 8 with our guest lecturer, Ms. Vita Peel, under the flag title of Corporate Social Responsibility. Then in chapter 5, it is about more specifically the remaining group of creditors. And the remaining group of creditors is viewed from two angles. One, in solvent firms, so ordinary business, and distressed firms. So the word solvent comes from insolvent, which is one of those equivalents of default or bankruptcy, chapter 11, insolvent. Those are synonyms quite often. And then, how is it discussed? It is discussed how the legal strategies, the regulatory strategies, is facilitating those creditors. And two examples on the solvent firms. One is the affiliation strategy. How is it done? Well, yeah, 1 second. Yeah. 1 second. Well, one example is the legal obligation, because remember, regulatory strategies are just quick and dirty rules that oblige actors to do certain things. When it comes to affiliation for creditors, the quick and dirty rule is all the official documents of a legal person should indicate its legal form. The NV, BV, GmbH, SA, Limited, Incorporated, stuff like that. If not, the responsible manager is outside the line of care of duty. A silly rule, because what are we talking about? Stationery, in Dutch, briefpapier. How boring can it be? Secondly, rule strategy with this minimum capital. We discussed that. So the idea, the dream is, with obliging with rules, ex ante rules strategy, legal persons to have a minimum capital, creditors are happy. A failed strategy. And then, last but not least, in the distressed firms, the whole story we discussed with the standard strategy means that managers acting outside the duty of care should personally add their private property to the estate, making creditors happy. And then piercing the corporate veil, which is basically the same. So in a group of companies, if one subsidiary is bankrupt, then in many jurisdictions they say, well, but then the parent company is basically held responsible. So there they trash the whole concept of legal personality and they pierce the corporate veil and state, well, you are bankrupt, but the creditors can knock on the door of the parent company. Whoa, magic topic. If you're looking for a topic for your research paper, piercing the corporate veil. And then an exaggeration of theory with appointment rights that the trustee is appointed by the creditors. It's technically not completely true, but theoretically speaking, you could say things like decision rights, incentives, and the chapter 5.3. Ladies and gentlemen, I'm looking forward to Thursday and the first round of presenters, and wish you good luck. And then around these presentations, we will further discuss the topics. So it's not just presenting and go home, it's substance, because the whole aim is that you, thanks to your own effort, make a better final exam, because all those porters are filling the system. See you Thursday. Apologies.